Start. This appeal by special leave raises a question of the application of Section 403 of the Criminal Procedure Code. Stop. The circumstances in which this question arises are following: para. A complaint was filed against one person and the appellant under sections 120B 409 Indian Penal Code and section 5 of the Prevention of Corruption Act in the Court of Subdivisional Magistrate Darjeeling. Stop. Against the appellant. The complaint was instituted on March 2, 1950. Stop. As the West Bengal Criminal Law Amendment (Special Courts (Close) Act) came into force on June 23, 1949, the case was allotted to the special judge who found accused number 1 guilty but acquitted the appellant. Stop. Accused number 1 took an appeal to the High Court at Calcutta. Stop. Para. The appeal must therefore be allowed. Stop. The conviction and sentence are set aside and the appellant must be regarded as an under trial prisoner awaiting retrial if government so decides. Stop. He will continue on the same bail until such retrial. Stop. Para. On April 9, 1952, the West Bengal Criminal Law Amendment (Special Courts Amending (Close) Ordinance 1952) came into force and was replaced by West Bengal Act 12 of 1952 on July 30, 1952. Stop. On May 26, 1952, a petition of complaint was filed against both the appellants. Stop. It was stated therein that the High Court had held that the allotment of the case to the previous special court and all proceedings thereafter were invalid, and all such cases have been directed to be retried according to law and prayed for cognizance to be taken of the offences which both the appellants were accused of. Stop. It may be pointed out that as far as the appellant was concerned, the High Court had given no such direction. Stop. Para. The special judge then summoned the appellant, who pleaded the bar of Section 403 Criminal Procedure Code, basing it on his acquittal by the special judge. Stop. The special judge overruled this plea on the ground of want of jurisdiction of the previous special judge to try the offences because Section 4 of the Act had been declared ultra vires by the High Court. Stop. Against this order, the appellant moved the High Court under Articles 226 and 227 and under Section 439 of the Criminal Procedure Code for quashing the proceedings before the special judge. Stop. On August 22, 1952, he was suppressed and he passed an order on August 26 that as the court had no jurisdiction to continue the trial, the case be filed and the accused be held underwater prisoner pending a retrial according to law. Stop. The appellant thereupon amended his petition in the High Court. Stop. The High Court dismissed the application and discharged the rule. Stop. It held that as the Act creating the special judges courts has been declared ultra vires the decision of that court had no binding force and that the High Court did not discharge the accused persons altogether but directed that they were to be held as under trial prisoners, leaving it to the government to decide what further steps the government would take. Stop. Here again there was an error, because whatsoever might be the legal consequence of the order of High Court in appeal, there was no specific order as to the appellant. Stop. The West Bengal Criminal Law Amendment (Special Courts) Amending Act having come into force by a notification, the case of the appellants was allotted to the special judge at Darjeeling, and a fresh complaint was filed in that court, and it issued process against both the accused. Stop. The appellant again took objection to the restarting of the proceedings. Stop. The other accused took a revision to the High Court. Stop. The High Court quashed the proceedings in the High Court of the Special Judge at Darjeeling on the ground that the Amendment Act was inapplicable to the facts of the case. Stop. Para. The position in law therefore was that the proceedings against the petitioner were pending in appeal before this court. The appeal was disposed of and a retrial was ordered. Stop. There has not thereafter been a termination of those proceedings. Stop. If consequently the Special Courts Act does not apply to those proceedings, and those proceedings cannot be tried by a special court, that position cannot be escaped by filing a fresh petition of complaint. Stop. The filing of fresh petition of complaint will not institute fresh proceedings distinct from the proceedings that were pending in appeal. Stop. So long as these proceedings have not been disposed of in accordance with the law, fresh proceedings cannot be instituted against the petitioner. Stop.